Welcome to From Our Perspective. Today, I'm joined by civil litigation partner Joe Lico. We'll discuss a homeowner's battle against their HOA over a parked RV. The lawsuit centers around unpaid fines, charges, and legal fees imposed by the Homeowners Association. This case went to trial and we won a significant victory for the homeowners. Joe, thank you so much for joining me today. Tell me more about our clients and how this dispute started.
So this initially started as an HOA dispute where the HOA had filed suit against our client because they said, the HOA, that they did not, our clients, pay assessments that were due and owing. And as I'm sure people are aware, when you don't pay something, ultimately interest starts to accrue, late fees accrue, and ultimately the case got passed off to an attorney who then was assessing attorney's fees as well. So what started out as a small amount for assessments that were due and owing actually then multiplied 500 times over with late fees, interest, and attorney's fees.
And what were some of the key arguments and evidence presented in court in this case?
So this was a matter of what steps did the HOA take to notify our clients that this amount was actually due and owing, and then what steps did our clients take to try and pay and actually pay as much as they could. So in this matter, the HOA was found to have switched property ownerships or property managements 2 or 3 times over the course of a 3-year period. They were unable to demonstrate the proper mailings, the letters get sent that were required to get sent because they show that our clients actually received them. And then, believe it or not, our clients tried multiple times to pay a lot of these assessments and were just referred repeatedly back to the attorney's offices to pay, but they were attaching, like I said, the interest, the late fees, attorney's fees, and actually got locked out of the portal so they couldn't even go in and pay. So rather than work with our client, the HOA actually decided to just sue them for, like I said, 500% more than was actually ever due and owing.
You mentioned the instances of mismanagement and poor communication. What part did that play in the outcome of this case?
It was a big factor because part of what the HOA has to do is show that certain criteria and factors were met by them, including mailing the proper notification, allowing the homeowner in this case to pay the bill. And with the changing of the property managers, they could never demonstrate what letter was sent, if it was received, what the letter even said, and who it was sent by. So that was a major factor in what did our clients do wrong and what was the expectation when they were never notified as to what they were supposed to do.
And how did you prepare to counter the HOA's claims of unpaid fees and assessments?
Well, we first, of course, started with the client and got their version about what had happened, and then we went through digging through all of the HOA documents we have a right when a lawsuit's been filed to have them prove their case. And so we requested the documents, show us the letter, show us any kind of mail log, show us who was in charge at that time. And so we made a lot of those requests. And then when we saw that they weren't able to provide proof of that, it became a question and answer session, a testimony on the stand. And that's what we brought forth to the court was they can't show that the letter was sent. They can't even show what letter was sent, who it was sent by, when it was sent, to what address it was sent. And so the court deemed that there was really no proof that the HOA did what they were supposed to do and that our clients were able to show that they tried to log into the portal, they tried to pay, they actually did pay all the assessments, but they didn't pay the interest and attorney's fees because they felt like they shouldn't have to. And so the court agreed and said that they actually should have allowed the client to pay, not lock them out, and never brought this lawsuit forward.
And ultimately, what was the court's decision? How significant was that for our clients?
The court's decision was that not only did our clients win, but they found that the lawsuit by the HOA was frivolous and groundless, which means never should have been brought, wasn't based on good faith. And that's very important because not only do our clients not have to pay any more to the HOA actually now has to pay our clients their attorney's fees because they brought forth a bad lawsuit.
And if someone is watching in a similar situation in a dispute with their HOA, what advice would you give?
Call an attorney right away. Robinson Henry does HOA disputes all the time. You're going to want to document everything as well as you can to show what notices you've been given, what you've done to try to correct the situation, and then do your best to try to iron out the situation so that you don't have to go to court. No one wants to go to court, but you definitely want representation because it's going to help you in the long run to not have to pay anything that you shouldn't have had legally to have to pay.
Great advice, Joe. Thanks for sharing your perspective.
Of course.
If you are a homeowner facing questionable fines and fees by your HOA, our team can help you. Reach out to us for a case assessment on our website or give us a call.